'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure.
So this next topic that we're going to deal with, statutory interpretation, is probably the one that you might run across most in real life. We don't spend a lot of time doing it because I think that you'll need to think about these rules when you actually want to use it at work, and you'll have a lot of guidance at work if it becomes part of your job. But a lot of us are going to have to deal with legislation as part of our role, whether it's OC health and safety, consumer and competition law, etc. And so being able to actually read and understand how lawyers think about the law that's before them is an important aspect of what we do. So this is a very, very brief introduction to statutory interpretation and some of the key concepts that go into how judges read statute or legislation, parliament-made law. So here we've got a couple of examples of where someone has written something that might be a law, but it's unclear. So the first is, of course, a hypothetical. Well, I think it's an amusing one, but that's just because I like dad jokes. But you get the idea, right? Often when we write something, it can be ambiguous or interpreted multiple ways. So let's have a look at these two examples. So the first one says, by law, audience members are not allowed to bring glasses onto the dance floor. So, the supposedly humorous element is, does that mean you can't wear spectacles onto the dance floor? Why not? Because that's what it says, right? You're not allowed to bring glasses onto the dance floor. There's a real world example that has been used by Justice Kirby, former High Court Chief Justice, who was explaining how statutory interpretation worked. And he used a case that he was involved in about a bank robber. So what happened was there was an interview of this bank robber, and after the official interview, they start processing the criminal. And as he does, he's being filmed by a camera in the corner, so he doesn't know he's being filmed, being recorded on the way to the lockup, and the police are joking with him, and he starts to reveal details of the crime that you could only have known if you committed the crime. So what's the problem here? Well, the law in Western Australia at the time said evidence is only admissible if it's on a videotape, which is a recording of the admission. And videotape was defined to mean any videotape on which is recorded an interview. Okay, so the question becomes, videotape only means videotape of videotape of an interview. So the question is, can this apply to the recording of the processing, or does it only apply to an official interview? So that's a real world example of where the statute wasn't clear. So what we have is a situation where legal writing can be difficult to understand and may say things that were never intended by the authors. So judges have developed these ways of interpreting these ambiguous statements. And through statutory interpretation, our courts really start making the law, or at least, as Sanson says here, by giving broad or narrow interpretations, they can expand or contract the area of law governed by the statute. So what we have is a situation where we have a piece of legislation or a piece of parliament-made law where there are two competing but plausible meanings. Stat Interp has developed a body of law to interpret that ambiguous statement using both common law rules and statutory requirements. These are very closely related, as Spiegelman points here, and it's one of the reasons that we go over the old common law rules, because they're very similar to what we would call under statutory approaches. So the literal rule becomes textualism, the golden rule becomes contextualism, and the mischief rule becomes purposive interpretation. But they're all using roughly the same logic. So specifically, we're going to deal with three key approaches. Original common law rules, which the judges developed, the purposive approach, and then the contextual approach. So let's look at some examples of traditional common law rules. There's actually a lot more rules than the 4 that we have listed here, but this isn't a course about statutory interpretation. So we're going to deal with 4 of the more important ones that have a parallel into legislative statutory interpretation rules. And so these 4 will really help us get an insight of how judges think when they're reading a piece of legislation. So the first one is the literal rule, and it means that when we're reading a text, we read it literally. You give the words their ordinary meaning. Our case for this is Fisher and Bell. It's an interesting case where a shop owner had a flick knife for sale in the window of their shop. Now, a flick knife is a knife that springs out a blade, and they were actually illegal under, I think it was the Weapons Act in the UK. So you're not allowed to sell them under the Act. Okay. The problem is that the flick knife was on display for sale, so it wasn't actually being sold. And as we come to in contract, right, having goods on display is not an offer to sell. It's actually something called an invitation to treat. So because literally the shop owner wasn't offering to sell the flick knife, there was no crime. Literally, he wasn't offering to sell it. It was an invitation to treat. Okay, the second rule we're going to deal with is the golden rule. Now, the golden rule is used when the result of reading it literally results in an absurdity. So the example that we have here is Liam Knapp. So this case deals with a situation where road laws said that after an accident, you had to stop. Okay. So in this case, one of the motorists had an accident, and one of them stopped and then just drove off immediately. Okay. Now, their argument was that they had literally stopped and so therefore complied with the law. But the judge looked at that and said, look, that's absurd. The point of stopping is to check that everyone's okay, maybe exchange details. The idea that if you crash, all you have to do is literally stop and then you keep going would lead to an absurd interpretation of the law. So the golden rule said that the person had not complied with the law. The final rule that we have here is the mischief rule. It's an interesting one because it can sound like the golden rule, but it isn't. The mischief rule says you should look at the mischief that the law is trying to solve. Okay, what is the problem the legal text is actually trying to address? A great case for this is Smith and Hughes. So what you had in this case was a street where prostitutes used to frequent, and they would be trying to get customers. So Parliament brought in a law that said it was illegal for prostitutes to solicit clients in the street. So what all the prostitutes did was they went back into the buildings and up onto the balconies and started calling out to people in the street trying to solicit customers. So this is a question for Parliament now, is soliciting from the balcony soliciting customers in the street? Now, at first, you might be tempted to solve this with the golden rule, right? And say, well, it's absurd, da, da, da. But actually, Parliament might have a law where they make it illegal to do something in public when you're in the street, but not illegal to do it in private when you're on private property in your own balcony. So it's not necessarily an absurd result to say they're not allowed to do it in the street, but they are allowed to solicit from the balcony. Okay, so hopefully you can see that's not necessarily an absurd result. So instead, they have to look at the purpose of the legislation, which is to stop people walking down the street being annoyed or being solicited by prostitutes. So because that was the mischief trying to be solved by the law, it was interpreted to say they weren't allowed to solicit from the balcony. So there we have it. 3 key common law rules: the literal rule, the golden rule, and the mischief rule. Which one applies? There's a lot of different situations for that, and we're going to go a bit later into how they might fit together. But in essence, there's no strict answer I can give you to that, right? If there's an absurdity, you're probably going to use the golden rule. However, it does get modified from time to time. So for instance, if it's a criminal issue, things get read narrowly. So it is more complex than what we're putting here. But very roughly, I think you can see that the judges would use the rule that most applies to the situation before them. Now, while we do have these common law approaches, there has also been legislation put in place that instructs judges how to read legislation. Yep, you've got it. There is legislation on how judges read legislation, and they're called the Acts Interpretation Act. We have one at the Commonwealth level, and we also have one at the state level. And what do they say? Well, a key section is section 15AA, and it says that interpreting a provision of the Act, the judge has to use the interpretation that would best achieve the objects or the purpose of the legislation. Okay, so what we really have is kind of like the mischief rule, but it's the purposive approach because it's required by legislation. So what's the effect of the purposive approach? Okay, well, we know that legislation trumps common law, so therefore judges have to use it. So what happens? If reading the text literally doesn't reveal the meaning of the text, the reader or the lawyer and the judge should refer to the purpose of the author when drafting it. Put differently, a legal text should be interpreted to promote the purpose or the object underlying the text. Sometimes that's contained in the objects section of the Act, but very importantly, courts are now able to look at extrinsic materials where there's ambiguity. What can be those materials? Explanatory memoranda. Really importantly, ministers' second reading speech, which is where they talk about why we need the Act. So go back to Module 3 to see how Parliament approves a law and why that becomes so important. So the judges can look at these other things when they're working out what the purpose of the Act is, and they interpret the legislation in light of that. Now, while you might be tempted to think that the purposive approach kind of trumps everything, it's not really quite how it works. And we can see this reasoning from Kirby here in talking through the approach to statutory interpretation in law in Australia. So where you start is with the text of the legislation, okay? If you can interpret that, that's all you need. So you're really using the kind of literal law. I meant to say the literal rule. Okay, so what happens if you can't, if that's not enough, you can look at the object of the particular piece of legislation and what its purpose is and use that to help you interpret the specific piece of law before you. And then finally, you should look at how those words are to be interpreted in light of the words around it, that it forms part of the whole law, just not an isolated part of the specific piece of legislation, which is how they were treated in the old days under the literal rule. So we've got this kind of cascading effect. Literally read the text, look to the purpose of the legislation, look at how these words fit in the context of the legislation around it. Looking at this context around the words is called the contextual approach. And how does that actually work? So an example might help us. Consider a provision where all building personnel shall not go within 5 meters of a crane without foreman approval. Okay, so there's a double meaning of crane, right? It can mean the thing that lifts heavy objects, or it can mean a waterfowl. Okay, so imagine they're on a working site where there are waterfowl around. Are they not allowed to go near the cranes? So in first instance, it's not clear from the literal rule, you know, if you just read that piece of legislation, whether birds are excluded. Secondly, you know, there might be some danger in waterfowl, like it might scare workers, or there might be some other reason. They might catch a disease off the bird, etc. So if you looked at the purpose of the legislation, which is probably to protect workers, right? It's still not 100% clear that cranes don't mean waterfowl. So what you would have to do is look at the act of a whole as a whole in other legislation. And it's probably going to be talking about equipment, safety on the work site, etc., all of those things. And once you read that piece of legislation in that context, it becomes clear that crane means the object that lifts things, not a waterfowl. And so you can follow a flow chart like this to understand how these key rules fit together. Okay. First, is there a clear single meaning of the provision? Yes. Does the context suggest a different meaning? No. Does the purpose of the act suggest a different meaning? No. Use the literal rule. Is there a single clear meaning of the provision? No. Does the context suggest a clear meaning? No. Use the purposive approach. Okay. I'll leave you to go through these specific questions and the flow chart, but you get the idea, right? The rules fit together depending upon how the interpretation flows. So I wanted to finish off this section on statutory interpretation with a note on reality. We're not training you to be lawyers. However, hopefully we're giving you an understanding of how the law works and how lawyers think. Okay, so understanding how lawyers approach the problem, understanding how words can be ambiguous and how the meaning of those words is going to be solved by lawyers is a very useful thing, because no matter your discipline, you're going to come into contact with a lot of legislation, most of which is going to require some form of interpretation. Whew. That's actually a very important section of the course. What we're going to go on and do now is look at some ways that we can think about problems. Use of logic, logic in general and logic as it's applied in law.